I want to talk about the 1-2 punch, devastating punch that Donald Trump was hit with on Friday, and why Donald Trump is doomed if he tries to appeal Judge Tanya Chutkan in Washington, D.C.'s ruling denying his motion to dismiss on the grounds of absolute presidential immunity and other constitutional grounds. I'm Ben Meiselas, and this is the MeidasTouch network, where we do deep dives into all of the legal filings and conduct thorough, fact-based legal analysis. So, two important things happened on Friday in the Washington, D.C. federal criminal case against Donald Trump, which is currently set for trial on March 4th, 2024. This is the case involving Donald Trump's attempt to overthrow the results of the 2020 election. Earlier in the morning, there was a ruling by the D.C. Circuit Court of Appeal affirming a lower federal court's order by federal Judge Amit Mehta denying Donald Trump's motion to dismiss on presidential immunity grounds in a civil case, not a criminal case, in a civil case brought by former members of, or current members of Congress, some former members, but mostly current members of Congress, and Washington, D.C. police against a former president. There you go. And it is for civil monetary damages regarding the January 6th insurrection and Donald Trump aiding and abetting that insurrection. There were a motion to dismiss by Donald Trump in the Washington, D.C. federal court. It was assigned to Judge Amit Mehta. Judge Amit Mehta analyzed two cases, critical cases, involving kind of the different spectrums of where presidential immunity could apply. There was the Jones v. Clinton case where President Bill Clinton was being sued civilly for things where he was not a United States president, things that predated his term. And there the court said that there is no presidential immunity while you're not in office. And then the other case was the Fitzgerald v. Nixon case, where a federal employee who alleged he was wrongfully terminated sued Richard Nixon. And after Richard Nixon was in office, there the Supreme Court said that there was a presidential immunity for all of the things that even fall within the outer perimeter of the presidential duties. And because hiring and firing is an executive function, even unlawfully wrongfully terminating a federal employee, retaliatory termination, you would still get immunity even if you're a former president, because the hiring and firing function is something that falls within the scope of what a president is supposed to perform. So then the D.C. Circuit Court of Appeal and Judge Amit Mehta had to basically analyze, okay, well, Donald Trump's conduct on January 6th, where does that fall within Fitzgerald, where there is immunity, and the Jones v. Clinton case, where there is no immunity. Immunity, no immunity. And ultimately, where Judge Amit Mehta, the federal trial judge, found is that Donald Trump's conduct, first and foremost, fell outside of even the outer perimeter, attempting to overthrow, to topple a government, destroy the Constitution, should not be afforded constitutional immunity. And also, as Judge Amit Mehta held, Donald Trump's conduct was political conduct. It was not within the focus of what his scope and duties when he was disgracing our office as a United States president. It was part of his campaign activity. So on that basis, the federal judge Amit Mehta denied Donald Trump's motion to dismiss. There's been other cases that have been consolidated there as well, from members of Congress, other D.C. police, and other individuals as well who filed lawsuits related to January 6th. That went up to the D.C. Circuit Court of Appeal. Friday morning, the D.C. Circuit Court of Appeal affirmed the lower court Judge Amit Mehta's ruling and basically said that Donald Trump's conduct was done in the scope of his campaign activity. It was political activity. He was holding a quote-unquote Stop the Steal rally where he was spreading these deranged conspiracies about an election that's not within the functions of a United States president. That is somebody campaigning. That is separate and distinct conduct. So they affirmed Judge Amit Mehta. So that was a big ruling earlier in the day that Donald Trump does not have that Fitzgerald v. Nixon immunity that Nixon had of a former president in a civil case.
Let's face it, working out is hard, and the cost of personal trainers makes it even harder. That was until I linked up with Copilot. My Copilot has had a transformative impact on my exercise journey. So here's the deal. The My Copilot service links you with an affordable, real-life personal trainer at basically the touch of a button. From there, you get personalized workouts tailored to individual needs and goals. You have real person accountability. You have flexibility with a schedule to fit your life, and you have expert training that is affordable. My favorite thing about Copilot is that my coach keeps me accountable while also understanding that life sometimes gets in the way. The flexibility of the schedule with the incredible enthusiasm and passion my coach brings to the table really keeps me wanting to come back and continue to work even harder. Like you, I have meetings or appointments throughout the day, and I can't be stuck spending too much time at a physical gym, or I'll never get my tasks accomplished. With my Copilot, I'm able to work out from the comfort of my own home on my terms. I've been using my Copilot for a little while now, and the energy that's come back to me from all these workouts, well, it's just been incredible to see. It truly is fitness made easy. Now, I'd love for you to follow my lead, to get fit and feel fabulous. Give Copilot a try. To find out why it's listed by Forbes as the top-rated personal trainer app of 2023, head to go.mycopilot.com/Meidas to get a 14-day free trial with your personal trainer. That's go.mycopilot.com/Meidas to get a free 14-day trial with your very own personal trainer. Take a back seat and let Copilot help you reach your fitness goal.
So then you move to Friday night. And Friday night, the federal judge, a colleague of Judge Amit Mehta, they're both superstar federal judges. Judge Tanya Chutkan, who's overseeing the Washington, D.C. federal criminal case against Donald Trump, she issues a 48-page ruling denying Donald Trump's absolute presidential immunity argument, and also denying Donald Trump's motion to dismiss not just on absolute presidential immunity, but also on various constitutional grounds like First Amendment, double jeopardy, and due process. And what Judge Tanya Chutkan said, and this is perhaps the most powerful line of her entire ruling, she says, defendant Donald Trump's 4-year service as commander-in-chief did not bestow on him the divine right of kings to evade criminal accountability that governs his fellow citizens. No man in this country, not even former presidents, are so high that they are above the law. And what Judge Chutkan said is that this case does not, I don't have to address even the Fitzgerald v. Nixon civil immunity for monetary damages, because Donald Trump's conduct here, as alleged in the indictment and for the motion to dismiss stage, we accept an indictment and all of the facts in the indictment as true. Donald Trump's conduct is being alleged is criminal conduct, not civil conduct. And when you go through the text, structure, and history of the Constitution and the concepts of presidential immunity, the same factors that may make immunity applicable in the Fitzgerald v. Nixon type of setting, within the outer perimeter of presidential conduct, that doesn't apply when you're dealing with criminal cases. Our founders did not want presidents to be above the law, to become kings. Our Constitution was done and drafted in a way that would curb the excesses of kings. That's the very basis, one of the very bases of our United States Constitution. And so she says, go look at the text. There's nothing talking about absolute presidential immunity. Go to the structure. The same structural immunities that apply in a civil context do not apply in a criminal context. Look at the history, and there's no history supportive of presidential absolute immunity for current or for former presidents. And Donald Trump is the former president. He's not a king. He's not subject to absolute presidential immunity. So let's talk about how these rulings are related now. What the DC Circuit Court of Appeal did, remember, that's the court of appeal that oversees the federal trial courts. What the DC Circuit Court of Appeal did is basically provide double protection, if you will, for why Donald Trump will lose when he appeals Judge Tanya Chutkan's order. So now there's really two arguments Special Counsel Jack Smith's team is going to make. And I should note this, that Donald Trump, when it comes to an issue of absolute presidential immunity, or when you assert immunity defenses like this, Donald Trump will have the right to what's called an interlocutory appeal, meaning an appeal before a final judgment. So Trump will bring this appeal, we'll see very, very soon. As I'm recording this, he could be filing a notice of appeal. So I want to just flag that because he's going to bring that notice of appeal right away. And so now what the DC Circuit Court of Appeal is going to say is, look, a 3-judge panel, including Judge Katsas, who's a Trump-appointed judge, and there were 2 other judges, all basically reached the same conclusion that this campaigning activity by Donald Trump fell outside of even the outer perimeter where you can have absolute immunity, like in the Fitzgerald case. So argument number 1, Donald Trump's conduct, his criminal conduct, was in the context of campaigning. Look at what the DC Circuit Court of Appeal just ruled in affirming Judge Amit Mehta. Campaigning activity outside of the outer limits of presidential immunity if this was a civil case. But now here's what I'm talking about with double protection about why Donald Trump's going to lose in the DC Circuit Court of Appeals. Protection 1, campaigning activity outside the outer perimeter. Now, you know what number 2 is, why it's double protection, because as Judge Chutkan ruled, criminal conduct is not subjected to the same Fitzgerald v. Nixon and the Jones v. Clinton analysis of the civil liability. Criminal liability not subject to absolute presidential immunity. Criminal liability of a former president certainly not subject to absolute presidential immunity of a former president. And then you can have the backstop of, and the DC Circuit Court of Appeal ruled that campaigning activity, election activity, is nothing to do with the roles and responsibilities of a president or former president. That's outside the outer perimeter of executive functions. So you have all of those arguments now. That's why it's a 1-2 punch right there. And I want to say this, Judge Chutkan's 48-page ruling was thoughtful, it was piercing, it was incredible. You combine that with Judge Amit Mehta's ruling, the DC Circuit Court of Appeal, we're talking about sharp, shrewd judges here who have a mastery of the United States Constitution, the history, the Federalist Papers. It is an honor to be able to even read and geek out with you reading these opinions. And this spells big, big trouble for Donald Trump. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers. And while you're at it, make sure you go back and check out the interview I did with President Joe Biden in Pueblo, Colorado. It's on our feed. It's free. Go search for it. It's below. And I think you will enjoy that interview. And I'd love to hear your thoughts about that interview. I'm Ben Meiselas. This is the MeidasTouch Network, and have a great day.
Hey, Midas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.